My dad was diagnosed with skin cancer. His doctor suggested an alternative, which is this pill. This drug is sort of still like in an experimental phase. He was asked and signed a surgical consent form. If something goes wrong, can we still sue?
And that surgical consent form is going to have a lot of terms in there that most people aren't going to be reading. But I can tell you, I think the short answer to your question is yes, you still can for medical malpractice. You still can. You mentioned a pill. There's products liabilities issues in there too. Legal significance of that consent form is you're saying that you're aware of the risks, you're aware of possible alternatives. That's what that is. So it would be more difficult to make the argument that I didn't know what I was getting, because you are consenting to whatever procedure you're getting. You're also stating that there are some risks. I'm aware of those risks. But that wouldn't preclude claims for saying that the way the doctor implemented that procedure or that medicine was harmful, you would still be able to bring a claim. In medical malpractice lawsuits, there's a lot of procedural hurdles. It's unlike most civil lawsuits that we do. In medical malpractice lawsuits, you have to give the physician or the hospital that you're suing a certain statutory period of time to put them on notice that I'm going to sue you. So here's a chance to resolve the case with me. That is a possible, if you don't do that step, right? If you don't get an attorney who's done these cases before, that could affect your case. It could get kicked out. I have seen cases where judges go, well, you didn't follow this procedural hurdle. So the first thing is make sure that you get an attorney that has done medical malpractice cases before, is aware of the procedural hurdles before you can initiate a lawsuit. And usually, such as our firms, we'll have a network of physicians who are specialized in that certain area of the medical field. So when you send that initial demand letter to the physician or the hospital, which is essentially what it is, telling them that you're going to sue them, it's also accompanied by a medical professional's declaration, an expert opinion. So it's really important that you treat a medical malpractice case different from, let's say, a business dispute case or a car accident case. There's a lot of different hurdles that you have to consider. I could go into length about there. It's also governed by a statute called MICRA, which is the medical malpractice statute. One of the major limitations of medical malpractice lawsuits is that it limits non-economic damages. So that's something to think about. The statute of limitations are different from a bodily injury case. So many considerations to think about. It's important to talk to an attorney that's done this before.